Hello, I'm Locke Meredith, and I'd like to invite you to join me on the next Legal Lines. We have Judge Jimmy Kuhn. He's a Court of Appeal judge for the First Circuit in the state of Louisiana. And Judge Kuhn is going to talk about being a trial court judge in Livingston Parish and how that differs from other parishes, how those judges handle things differently. He's also going to talk about being an appellate court judge and all of the issues, frankly, a day in the life of an appellate court judge and how they deal with them. And he's also going to talk about the new mediation program at the appellate level, which is very successful. So join me on the next Legal Lines. Welcome to Legal Lines. I'm Locke Meredith, and I'm very pleased to have on the show today Judge Jimmy Kuhn. Judge Kuhn is with the First Circuit Court of Appeal. Judge, thank you so much for being on the show.
Happy to be here.
Tell the folks a little bit about yourself.
Well, like what?
Well, just a personal background.
I live in Ponchatoula now. I grew up there. I'm number 8 of 9 children,
Wow.
like my parents said. That's what I say, too. Went to Southeastern and then to Loyola Law School.
And got out in private practice, and what'd you do?
Well, initially, I practiced law in Hammond with a firm that no longer exists. It was Pittman Matheny, which was a firm that did exclusively, by and large, insurance defense work. When I started practicing there, they did most of the defense work in the Florida parishes, except for 2 or 3 insurance carriers, so it was a very active practice. So they had...
Threw you in the water quick, I imagine.
The day after I got sworn in, I was given a file to go to Franklinton, Louisiana, and try a case. So, yes.
I've heard those stories before.
Yeah.
So how'd you do?
I lost,
oh, well.
as I should have. But after that, I started practicing law in Livingston Parish, and almost 20 years here before.
What kind of law did you do? Pretty much everything?
Well, started off doing a lot of title work, slipped away from that doing plaintiff's work, but meanwhile, I was also doing a lot of domestic cases.
So you came with the gambit.
Yeah, and then eventually at the end of my career of practicing, I wound up representing some insurance carriers and doing plaintiff's work, so effectively I was in the courtroom 5 days a week.
Interesting mix, too.
Yes, it was.
How did you get into the kind of not politics of the judiciary, but the bottom line is you're elected. How did you end up running for a trial court judge?
Well, what happened, as you would expect from practicing law that period of time, I bumped into a lot of lawyers, and I was quietly sitting at my house in Denham Springs then, and some friends of mine, some lawyers from Hammond, came by my house and asked if I'd consider running for judge. But then after 2 or 3 weeks of discussion with my family, I decided to run.
And we were talking a little bit often. You said part of the reason was for family and how hard lawyers have to work. You're pretty worn out, huh?
Yeah, what happened was I was working 70 to 90 hours a week because even though the court may have closed, then of course I'd have to go back to the office and attend office work, and then in the evenings I'd have to be getting ready for the next day. And though our practice was very successful, I made the decision to run premise on the fact that I just changed quality of life.
Yeah, I don't think people understand how difficult it is to be a lawyer.
Yeah. Well, if you go to court, it's not a 40-hour-a-week job if you want to be successful and adequately represent your client.
Do a good job.
Yeah.
You got to dig in.
Right.
So you ran for trial court, and of course you won the first time?
Right, sure did.
And tell me a little bit about that. What was it like to run for a trial court judge?
Well, I was practicing law and living in the 21st District, and as you know, of course I don't know what audience may see this, but the state's divided into districts, hence the name District Attorney or Judicial District. But the area was Tangipahoa Parish, Livingston, and St. Helena parishes. So it was a sizable area, but not too big that I couldn't actually get on the road and virtually see everyone in the 3 parishes, which was enjoyable. I enjoyed the experience a great deal.
And were elected.
Got elected, and then whenever I took the bench, I had agreed that I would handle exclusively family court, which involved juvenile cases, divorce cases, custody cases.
That's a tough area to law.
It's very tough. It's very emotional, and that likewise required a great deal of time because handling all of those cases in the three-parish area. That practice has since ceased, and now all of the judges in those three parishes hear any type of case, including criminal.
And of course, here in East Baton Rouge Parish, it's different. As you know, the guys who are elected generally go down to the criminal bench and spend some time there.
Right.
We have 3 to 4 judges that deal with the family court issues and litigation, and then we have the civil judges.
Right.
But there in Livingston, or in the 21st Judicial District, the judges see everything.
Right. And
what do you think? Do you think that's a good idea?
well, it may have been a long time ago, but you know, there's been such a, particularly in that judicial district and other ones, for example, the one that includes Ascension Parish, there's so many people that have moved, and the amount of court activity has increased. The courthouse facilities can't keep up with the activity, and let's use family court, for example. If you have to wait 2 or 3 weeks until the judge in your case rides circuit for you to get to court.
And explain what that means to ride circuit.
Okay, well, what happens when you're in a multi-parish district like the 21st, a judge can't be in all 3 courts.
So you got to travel.
You got to travel, and so you have to work up a schedule and try to adjust it where you spend the most time in the parish where there's the most activity. And the consequence of it is there may be something that really needs to be heard in Livingston Parish, for example, but because of the travel requirements, both the St. Helena and Tangipahoa Parish cases are delayed. Whereas if you had this specialization, if you will, for example, criminal court, family court, and then civil court, it would alleviate some of that. And by the way, I've spoken to some legislators.
I was wondering how you go about changing it.
Well, you'd actually have to have the legislature make some changes and provide for those specialized courts. And there's been 2 of them that represent the 21st District said that they are in total agreement that those 3 parishes get additional judges, but they'd like some kind of specialization.
I know, because Livingston and Tangipahoa got to be, what, 2 and 3 in the fastest growing parishes in the state?
Well, I'm not sure about their rank, but they are amongst the top 10, certainly.
It's moving fast.
So, and statistically, they already need additional judges, and the question is, where do they go?
How many trial court judges in the 21st right now?
8.
How many more do you think you need?
Well, statistically, I think that they're entitled to 2 more judges.
So you just got to wait for the legislature to act.
Right. Well, actually, what happens is the Supreme Court has a committee that was created that studies and makes a determination whether or not there's enough activity to justify additional judges. Once they reach that conclusion, then they inform the legislature, and the legislature takes action.
Where is it in that process?
I don't know exactly where they are since I'm removed from that process. And if I wanted to discuss additional judges, I would encourage people to consider the First Circuit Court of Appeal.
I understand. All right, so you're practicing law and then eventually get moved up to the First Circuit Court of Appeals.
Right.
I'd like to talk about that on the next segment.
Okay.
This is Locke Meredith, Legal Lines, and Judge Jimmy Kuhn with the First Circuit Court of Appeal, and we'll be right back. Welcome back to Legal Lines. I'm Locke Meredith, and again, very pleased to have on the show Judge Jimmy Kuhn. He's with the First Circuit Court of Appeal. Again, Judge, thank you so much for being on the show.
Happy to be here.
All right, let's keep going. We said we talked about kind of the history and how you got into the trial court level. Tell me how you ended up running for the First Circuit.
Well, what happened, God, it was 10 years ago now, 2 judges on the First Circuit from my area of the First Circuit.
And you're District 3, is that right?
Well, I'm one of the 3 districts that the First Circuit is composed of. And this district is essentially the Florida parishes, save and except East Baton Rouge. But 2 of the judges from that area retired, and yeah, I just thought it was the right time to pursue it.
And what do you think of the election versus selection of judges? Because you've now had to run at the trial court local level and at the appellate level. You believer in it?
I don't think there's really any advantage to either merit selection or to election. I, however, believe that it's good for people to grade your paper, if you will, which is accomplished by election. Are there other ways? Yes, of course, merit selection. But as you certainly are familiar with, and I presume some of the audience anyway, there's drawbacks to that. That is, who makes that selection?
We've actually had a lobbyist discuss it. It seems like it comes up every legislative time that it can, and we actually had a lobbyist on the show and did a discussion about it.
But, you know, frankly, I feel about it, that's not my decision to make, that the legislature would have to do that, and presumably at some time the people of the state of Louisiana. And ultimately, that's what we want to know, is what do they want, and
bottom line is, the system seems to work to you.
Yes.
Describe a day in the life of a First Circuit Court of Appeal judge. What's it like?
Well, to understand that, you have to understand the job. Some people believe that if a case goes to the Court of Appeal, the effect of it is you retry the case.
Yeah, I have to explain that all the time.
Right. And, you know, there are certain standards by which we can reverse a trial judge. What effectively is being done is to determine if there was any errors made, either about facts in the case, about the law, or where a judge has discretion if it's been abused.
The bottom line is at the trial court level is where the parties get together and all the evidence is introduced into the record, and then a judgment is made either by a judge or jury, and then it's that kind of box of facts and evidence that's sent up to you guys to evaluate if a mistake's been made as raised by either party.
Right. And the easiest way for someone unfamiliar with the court system to understand that is the use of the word trial versus the use of the word hearings. We don't have trials at the Court of Appeal. We have hearings. And as you know, and again, I'm sure some people in the audience know, what the Court of Appeal does is review the record. Years ago, the state Supreme Court mandated that every word in a court record be read. And sometimes that's not much of a issue insofar as the reading, though there may be great legal issues with great research. And other times it's quite interesting. A few years ago, there was a case involving a question DEQ, and over the summer I had 41,000 pages to go through. So,
and do you read every page, or how does your office staff help the appellate court judges? Because there's no way a human being could read everything.
No. What happens is the way I have the arrangement with the attorneys that work with me is we divide up the cases, they read the records, we discuss them. I make a preliminary decision about how I think the case ought to be looked at, and then after they examine the record and the transcript, do some research, if there's some issue, in other words, if there's something there that my preliminary conclusions would be wrong, well then we discuss it and we go from there.
So bottom line is, I guess do you come to the First Circuit Court every day, or how is y'all schedule as far as, I know there's times where you have the hearings and times where you're hearing arguments and all that. Explain that.
Well, to go back to the question preceding, the day in the life is you read a lot and you stare at a computer a lot, and there's quite a bit of emails and paper flying around. No, I don't come to Baton Rouge every day. I live in Ponchatoula and have an office there as well as here at the courthouse, and we have, the way the First Circuit has their system set up, we have court roughly every 5 to 6 weeks for 2 days, and the 3-judge panel will consider during that period of time 30 cases.
And how many judges are actually on the First Circuit?
We have 12 judges.
And there's yet 3 judges of the 12 will hear a group of cases that it hears. Right. All right.
And then, of course, as you know, there has to be some discussion amongst the judges to reach a conclusion as to how the case is going to be decided.
A lot of times, all of us lawyers who get to argue in front of you gentlemen sometimes wonder if the arguments are a total waste of time. Have y'all made up generally the mind before the argument is made? How does that go?
Well, to be honest, there's so much work at the First Circuit. It would be great to have done all the work on a case, and then when the attorneys show up to argue the case, have a preliminary draft of an opinion, have discussed it with your two fellow judges, and had a rough idea. The fact of the matter is that typically does not happen. Usually what would happen is the judges, at the minimum, review the briefs, read the briefs that are in the case, focus on what they think the issues are, and that's why occasionally when you're arguing a case you might have some questions.
Right.
So to answer your question, no, the case has not been decided at the time the lawyers come to argue, and do the arguments have any impact on the decision? Depends on the lawyer, the issues in the case, and how well they present their case.
Bottom line is it can.
Absolutely.
And so the word to the lawyers is be prepared.
Be prepared, know what the function of the Court of Appeal is, and by that I mean understand that we're not retrying a case, and know what the issues are. Be ready to talk about it.
So the decisions that the appellate court can render on an appeal are what? What
An oversimplified way.
Right.
We're looking at, are there any errors made in the trial court?
And of course the standard of review is different depending on what's in front of it, right?
The standard of review, of course, is that vehicle whereby you examine things. In some types of cases, it's just whether there's an issue about the facts, and so there's a standard of review for that.
Which is manifest error?
Correct. And then, of course, if there's been a legal error made by the trial judge, it's error of law, in which case, we presume it's interdicted the decision of the trial court, and so we then, in fact, look at it de novo, which means as if it's new, and render a decision.
All right, well, let's finish the types of judgments that the appellate court render at the next segment. This is Locke Meredith with Legal Lines and Judge Jimmy Kuhn with the First Circuit, and we'll be right back. Welcome back to Legal Lines. I'm Locke Meredith, and again, very pleased to have on the show Judge Jimmy Kuhn. He's a judge with the First Circuit Court of Appeal. Again, Judge, thanks. We're talking about the various decisions y'all render at the First Circuit, and we talked about, of course, the remand, which is what?
Remand is where the case is returned to the trial court, and there's many, many reasons that could be done. In a criminal case, the sentence might be illegal, so the defendant has to be resentenced. Sometimes the mistake may be made in a civil case opposed to personal injury, where there needs to be some additional evidence put on. Because the law says if we're able to look at it and conclude the case, we're obligated to do that. A remand only comes up where something's missing.
The other decision would be a reversal of the trial court, which is what?
As the word would imply. In a civil case.
You're wrong.
Yeah, right. Just reverse it, change the outcome of the case.
And that we've mentioned in criminal proceedings, either convict or not convict and disagree.
Right.
Or in a civil case, award damages or not award damages.
Correct.
And then, of course, you can affirm.
Right.
Which means?
We agree, and the decision to trial court is correct.
And then the next step that they can take at that point, a party, if they don't like what the First Circuit or a Court of Appeal judge panel renders, is take it to the Louisiana Supreme Court.
Well, attempt to, because as you know, the Supreme Court's what we call a writ court. That means
they don't have to.
You're not entitled to an appeal, but they may allow you to appeal.
Statistically, do you know how many matters come before the First Circuit Court of Appeal that are affirmed, or there's some problem?
I wouldn't know, but I would have to say as a general matter, the trial judges in the First Circuit, by and large, are very well trained and educated in the law, and in order to get a case reversed, you have to demonstrate there's been some
serious.
Yes. So I would say, if I had to guess, the overwhelming majority are affirmed.
Statistically, how many of the cases that go to the Louisiana Supreme Court case would you say are accepted?
Roughly, the Supreme Court decides 80 cases a year, and their attitude insofar as granting these appeals, if you will, is that if the outcome of the case is correct, even though the reasoning for winning or losing might be incorrect, that they wouldn't consider the case.
Let's talk about the caseload that the First Circuit has. You guys are different, I think, than most any other of the courts of appeal. Is that right?
Right.
Explain that.
Well, several years ago, when the courts of appeal, the most recent change would be a good number of years ago, the Court of Appeal in the New Orleans area was divided into two separate circuits, the 4th and the 5th. But this was so many years ago, and there's been such a great population shift within the state, throughout the state, that the overwhelming majority of cases that go to the Court of Appeal go to the First Circuit.
Not only that, because of population, but y'all have the seat of government fall within your district. Is that right?
Right. Well, and of course, in the middle of the election season, it's interesting because if you have a statewide elected office and there's a contest about the election, it has to be tried in East Baton Rouge Parish, and then, of course, we proceed to the First Circuit. And there's quite a few types of elective offices that fit that. And then questions about constitutional amendments, questions about the DEQ. Last year, the legislature decided they would move cases concerning oyster beds and issues with the state to be appealed to the First Circuit.
So here we go again.
Yeah. Anything involving government, by and large, comes to the First Circuit.
You mentioned that there's 12 judges, and a panel of 3 hears all of the cases. When are the circumstances where all 12 show up in here?
Well, as you know, that's called en banc.
Yes, sir.
And it comes up if the First Circuit wants to reverse itself in a decision. In other words, if a panel had rendered an opinion sometime prior and said the law read such a way, and the court decided in a meeting that we wanted to change the law for our circuit, we would go en banc. That is, all 12 judges would sit. Sometimes in election contest suits, it's mandated that we go en banc. And if we think it's a very significant legal issue that we need to address as a group, we might do that.
How is it decided that the group is going to consider this issue or decide that it wants to change the law or anything like that? Is there administrative meetings?
Absolutely. Once a month we meet, and if this issue comes up or these issues come up, some judge who has run across the case that deserves his attention, we bring it up, discuss whether we ought to consider the case.
Now, for a reversal to occur of a trial court level, it's got to be a unanimous decision by the panel.
That's right. 3 judges have.
So if 2 say we need to reverse it, but 1 says no, it's not happening.
That's right.
Well, how are y'all?
What happens then, Locke, as you know, you then go to 5 judges, and that's the process there.
Judge, how are y'all dealing with this case? Well, I think y'all's population is the folks that y'all have to deal with is astronomical. How are you dealing with it?
Well, I have some statistics that were at least 2 years old. Our district, which is 16 parishes, has roughly 1.4 million people. We have 12 judges. And the another circuit, which is unnecessary for me to mention, likewise has 12 judges, and they have 435,000 people.
Amazing.
So you could imagine that there's a great difference in the workload. The Supreme Court allowed us at the beginning of this year to start a pilot mediation program for Court of Appeal cases. We're the only court.
It's the pilot program, right?
Correct. And obviously, we're the circuit that most needs this. Frankly, I would tell you, at the beginning, I was not optimistic at all about how this would work. Because
I'm amazed.
If you won a case, you say, why would I mediate? Because I've won. And if you've lost, well, you say, well, I know that this was wrong. Well, I mediate. And I have been surprised at the outcome of it.
How does it work? Who's heading up the program?
There's a lady here in town who's a lawyer. Her name's Melanie Newcomb-Jones. We've hired her as the administrator for this pilot mediation program. She's then put together a list of mediators, and it's a voluntary program.
I know. I've gotten letters. I've gotten letters from Melanie that says, you filed this appeal, or the other side has, and do you want to mediate?
Right. It's not mandatory, and she asked the attorneys, would your clients want to mediate, and then should all sides agree to, she does. In the federal system...
And it's not her that mediates it, but it's this panel of lawyers?
Right. It's a panel of lawyers who are trained mediators, and then what happens is you're given a choice of who you would want to mediate the case. The lawyers agree on it. Right now in the pilot program, it's free to the litigants, to the attorneys, but we're hoping that we can keep it going, and it has a 50% success rate.
That is amazing to me. I cannot believe that.
Shocking.
So very successful.
Yeah.
Wow. Judge, thank you so much for being on the show. Look forward to having you back on in the future. This is Locke Meredith with Legal Lines and Judge Jimmy Kuhn. Thanks for being with us.